least we're between thunderstorms. So call the first case, please.
John H. Packard versus Jonathan Bentley et al.
We'll hear from the appellant.
Good morning, Attorney Kerry Bauer here on behalf of Mr. Sidney Gilreath. I'd like to reserve 5 minutes for rebuttal, please.
That'll be fine.
Thank you. Your Honors, this is basically at its heart a premises liability case brought by John Packard against the City of Gatlinburg pursuant to Tennessee Code 29-20-203 based on a condition of road signage at a crosswalk. As the court is probably well aware, the Great Smoky Mountains National Park is the most visited park in the national system, visited by more than 13 million people a day. The parkway leading from Pigeon Forge into Gatlinburg is thus one of the busiest traffic areas probably in the entire country. About 3 or 4 years prior to Mr. Packard's injuries, a lady named Ola Moore was injured at the same crosswalk. And so the City of Gatlinburg decided to have a meeting to try to see how they could make this particular crosswalk safer for pedestrians. And they came up with a plan to utilize flashing lights on the diamond-shaped pedestrian crosswalk signs. The first place I ever personally encountered those was, oddly enough, in Marco Island, Florida. And what stood out to me about them is that not only do you see the sign, but when that's flashing, you say, okay, not only is there a crosswalk there, but somebody's about to step into that crosswalk, so I need to prepare to stop, because otherwise those lights would not be flashing. Unfortunately, the City of Gatlinburg, over time, after installing these lights, failed to go out and make sure they continued to operate. And so for about a year prior to Mr. Packard's injuries, those lights had not operated. Mr. Packard candidly admitted that on the date in question, he did not attempt to activate those lights because he knew they didn't work. And I don't think there's any argument in this case that had he tried to activate those lights, they would have worked. Everybody admits they were not functioning. So this case, we feel like, is more akin to the Lawson versus Maryville City Schools case. And we cited in that case for the issue of had they gone out, I think that's the case, also under the public duty doctrine, but had they simply gone out and investigated this, they would have seen they weren't working, they would have repaired them, and it would have increased the safety at the intersection. The defense relies on a couple of other cases on the public duty doctrine to say when a duty is owed to the public at large, then no specific plaintiff can bring that case. They rely on Lawson versus Hawkins County and Ryan Kimball versus Dyer County. But in both of those cases, the county at issue did not own the road. And so the public duty doctrine was held to be applicable. In this case, as it turns out, the City of Gatlinburg does own the signs. The state of Tennessee owns the roads, but the county has the signage, and the county is the one that installed the flashing lights on the pedestrian crosswalk signs, which could be illuminated by simply pushing a button. And so we feel like this case is brought under 29-2203 and is consistent with Lawson versus Maryville City Schools, where in that case the city schools did in fact own the sidewalks.
Mr. Bauer, what did the experts say about the necessity of a flashing light?
Your Honor, that's a really good question. It was my next point, so I'm glad you went ahead and brought it. Both the court and defense in this case said that their expert said that the lights were not necessary, and our expert said that the lights were sufficient. So reading from page 42 of the technical record, our expert said at the crosswalk there are two 36-inch diamond-shaped signs with yellow background and with 8 small high-intensity bulbs around the outside border, which flash when activated. However, and this is what they seized on, the yellow sign alone placed at the crosswalk is sufficient to alert all drivers of the crosswalk presence and the requirement to yield to any pedestrian within the crosswalk. So he's saying, as far as the driver, he already has the benefit of the large markings on the pavement, and he's got the 2 signs on either side of the road. And so, okay, that's sufficient to say, okay, there's a crosswalk there. What it doesn't do is tell that driver, not only is there a crosswalk there, but somebody's about to step into it. So what the court apparently overlooked in referencing our expert's testimony is at page 44 of the technical record, the same expert says, the absence of the flashing lights and the crosswalk signs created a hazardous condition which could have been eliminated with reasonable care. Now, at the time that this report was prepared, Mr. Gilreath, I think, was operating under the belief that these signs belong to the state of Tennessee. So if you switch to page 46, make sure I'm telling you correctly on that. Page 45 of the technical record, it talks about Parkway is a street within the city of Gatlinburg, which is also U.S. Route 321, which is under the control of the Tennessee Department of Transportation. Who is responsible for safe operation of the intersection of Parkway and the crosswalk near Rocky Waters Motor Inn by its ownership of the 4-lane street, the marked crosswalk, and the sign and flashers placed there by the state. The state of Tennessee got out of this case because that turned out not to be accurate. It turned out that the signage, at least, was owned by the city of Gatlinburg. But it goes on to make under point B, it says, by installing a flashing signal / sign at this crosswalk, the Tennessee Department of Transportation assumed the responsibility to assure the signal would operate properly for the purpose it was chosen. So it's not exactly accurate to say that both experts agreed that it didn't make any difference whether they flashed or not. In fact, he says that was a defect, that they assumed a duty and it was a defect. Obviously, assumption of duty is a question of...
What did the experts testify, though, that was the standard of care? What was required? What was the duty that was required? Did the duty require flashing lights?
That's kind of honestly a gray area, Your Honor. When I got involved in the case, you're right. That's a hole in the argument. He seems to be saying that in this situation, they assumed a duty and then they failed that duty, and it seems like he's saying that that was a good a duty to assume. I think that's supported by the fact that the city of Gatlinburg, on their own, decided to have a meeting and say, we need these lights so this doesn't happen again. And so Mr. Gilreath, from day one of my involvement in this case at least, has always said, I don't understand why this isn't an assumption of the duty. The city assumed a duty. And so that's what we're saying, is that the city assumed a duty. A governmental entity can do that. And when they do, they have a duty to fulfill, or a responsibility to fulfill that duty in a non-negligent manner. And by failing to go out and make sure that the lights continue to do it, what they were intended to do, that increased the risk of harm to Mr. Packard. Does that answer your question, or as well as possible? So that's what this case comes down to. We believe they assumed a duty of care. It's a duty pursuant to 292203, which takes it outside of the public duty doctrine, because the public duty doctrine is trumped by a more specific, as said in the Lawson versus City of Maryville, or Maryville City Schools, is trumped by the more specific provision. Otherwise, it becomes a nullity. You would never have a situation where, in a premises case at least, I can't think of a situation where that duty wouldn't be owed to the public generally. And so, in effect, if you said public duty doctrine trumped that, then you'd never have a situation where it would be applicable, and 292203 would become a nullity. And so,
excuse me for interrupting, counsel, with reference to the public duty doctrine. Did your client allege any special duty?
No, I don't believe he did. I think that he just alleged that they assumed a duty of care that they then failed. And our expert, I think, as I pointed out in the record, shows that, yeah, that assumption of duty, the failure to proceed with that assumed duty, increased the risk of harm to Mr. Packard. I don't think he alleges that they assumed a duty specifically to him, as I don't know how he could, honestly. So, no, I would say not.
Thank you.
But that's the crux of the case. As to us, we feel like the city assumed a duty. They did that based on a perceived risk. Mr. Packard should have been able to rely on that, but he was not able to, because he knew the signs were not working. Nobody can test the signs were not working. And had they been flashing, we feel like more likely than not, Mr. Bentley, the driver, would have known, okay, somebody's about to step into this crosswalk, I need to stop. And that's how Mr. Packard got severely injured. So I think my time is about up for now. Thank
You
you.
have your time for rebuttal.
Thank you.
Thank you. We're here from the appellee.
My name is Benjamin Lauterbach. I have the privilege to represent the city of Gatlinburg in this matter. As this court is aware, we successfully argued a summary judgment motion in front of the trial court. Judge Sloan granted that motion. At its heart, this case is a duty case. It's not an assumption of duty case. It's not, and the primary reason for that is because that wasn't pled. It wasn't pled in the complaint. It wasn't raised at the summary judgment stage, and it's now before this court for the first time. There was no special duty pleading, as Mr. Bauer has conceded, and as the court has noted, there was no reference in the complaint to Section 203 of the lawsuit. In fact, the only reference to the Governmental Tort Liability Act in the complaint was with regard to venue and jurisdiction. So we would submit those issues are waived at this stage. We have briefed the inspection issue under 205, TCA 2920-205 subsection 4. We've briefed the public duty doctrine. We don't think it's necessary to even get there. This is a duty case. That's it. It ends and begins there, or begins and ends there, I should say. And Judge Sloan quickly picked up on that at the summary judgment argument.
Counsel, let me ask you, recent opinion, which the style of it eludes me since they reversed me. I can't remember the style of the case. But the Supreme Court wrote 4 opinions in it, and it seems like at least 1 or 2 of the justices questioned whether or not public duty doctrine needed to remain in effect given the stated immunities or stuff. Are you familiar with that?
The Lawson versus Hawkins County case?
Yes, thank you.
February 2023.
Yes.
When that was
Yes.
issued. I'm vaguely familiar with it.
Yeah, so am I. What do you say about that? The idea that perhaps the way the law is now with specific statements as to the GTLA and whatnot, that the
Yes,
public,
Your Honor.
especially since they've said that if it's ordinary negligence, if it's gross negligence, that doesn't include ordinary negligence and so on.
Right.
What do you say to the idea that perhaps now is a time to reevaluate the public duty doctrine?
Well, Justice Kirby, in her concurring opinion, really latched onto that, and I think telegraphed where she's going to go if that issue gets in front of the Supreme Court again. I've got a client here I'm representing. I know I want the public duty doctrine to apply, and I think Judge Sloan applied it according to the current state of the law. But to answer the court's question candidly, I think the public duty doctrine has seen better days. I suspect that soon will be on the way out. Now, that opinion, and I don't remember the specific example, but the author of that opinion wrote, in the opinion, gave an example of where the public duty doctrine would apply. And I apologize for not recalling that specific example right now. So there are certain occasions where I think it would still apply. But when you really look at the public duty doctrine, it was common law well before the GTLA. GTLA's passed. The Azell versus Cockrell case, I believe, came out in the mid-'90s and said it's still alive and well. But what it does is it serves as that extra layer of protection and when the GTLA may remove immunity. I believe that's still the current status of the law. As we sit here today, or stand here today, before this court, the public duty doctrine does require certain aspects, one of which that there must be a special duty alleged. That's not my word, that's in the law, that must be alleged to avoid that immunity attaching. And in this case, that hasn't happened. So we maintain that the immunity does attach, and the city of Gatlinburg should be afforded with immunity under the public duty doctrine, should this court first decide that the GTLA doesn't apply. I still come back to the issue of duty in this case. We have 2 experts, their own expert, and his word is sufficient. The sign without the lights was sufficient. Clearly their expert was confused. Clearly their expert made mistakes in his report. Be that as it may, ultimately his opinion was the sign in place with the lights on it, not working, was nonetheless sufficient. Our expert goes even further and specifically states the signage that was in place at the time of the incident at issue complied with all requirements of the Manual on Uniform Traffic Control Devices, the MUTCD. That's the manual, that's the Bible, if you will, on traffic engineering in the state of Tennessee, and has been codified through the statutes. He goes even further to state, our expert that is, the crosswalk signage in place at the time of the incident had LED lights around the outside of it, but they were not required, and even without them working, the crosswalk signage complied with all recognized engineering standards in the state of Tennessee. So what we have, respectfully, is the appellant in this case is asking this court to ignore the status of engineering standards in this state, and let's hold the city of Gatlinburg under this one circumstance to a higher standard. And respectfully, there's no law that supports why that should happen. The facts in this case are pretty basic and pretty, for the most part, undisputed. This gentleman, by his own admission, had crossed this roadway thousands of times. This was not his first rodeo, as they may say. The previous incident at this crosswalk occurred 2014, so 5 years prior. It's the only other reported incident at this.
Is this in the
crosswalk.
middle of downtown Gatlinburg?
Yes, Your Honor. If you're familiar with going towards the park, Hillbilly Golf is right there on your left. It's one of those crosswalks. Okay. And this is the only crosswalk that had lights. This was after this first incident 5 years prior, there was a community group that came out and said, what can we do? Well, the cities are bound by TDOT on these state highways. They can't go out and make changes to the roadway. They can't paint even on the roadway without permission from TDOT. So what's happened in this situation is they decided they would try this light system, see if it would work. The hadn't been working for a year argument. I'm not sure where that comes from. There's no support for that in the record. It did not work after the accident. We know it wasn't working. What would that have changed in this set of circumstances? You had a driver and the operator of the vehicle behind the driver who both testified, and it's in the record, and we've cited to it, that they saw the sign. They knew what the sign meant. They saw the crosswalk on the roadway. They knew what that meant. They saw the plaintiff. Who wasn't paying attention in the circumstance? And I'm loath to get into a fact argument here. I understand the way you're going to look at that. But really, this is very important. It's undisputed. The appellant in this case never looked to his left. What if the lights had been working? He pushes the button, they work, he still doesn't look to his left, he steps out in front of the car, we're right here. Nothing would have changed. At the end of the day, he didn't push the button. He never even attempted to engage the lights. How can an entity be responsible for an assumed duty when the person who is supposedly in the position to be protected by that duty never makes an effort, never does anything to be protected? Cities are routinely, when it comes to traffic lights and traffic signals, routinely we see lights are working sometimes, other times they're not. And what I mean by that is, if you think of a big city, you're crossing, rush hour, certain lanes are on, the next 9 hours later, those lanes are off. You get the X, you get the green light, they're not working at all. Cities will turn lights on flash mode at night. Routinely, there are decisions made within the city for certain reasons to turn lights on and off. There is no reason whatsoever to have had these lights on. None. They don't need them right now. And we'll never know what would have happened if they had been working and Mr. Packard had utilized them. But what we do know is that the duty that was owed in this case, the foreseeable risk, was met by the city of Gatlinburg. I'm glad to answer any questions the court may have. I raised the issue of inspection, and that's primarily based on the argument that the appellant failed to raise 203, failed to raise the GTLA, and the two paragraphs that asserted fault against the city, paragraphs 15 and 16 of the complaint, there's no reference to 203. There's no reference to the Governmental Tort Liability Act. Therefore, we submit you can go to 205 subsection 4, and immunity should attach to the city as a result of that. If they had alleged 203 liability properly, and if they had raised that at the Governmental Tort Liability, at the summary judgment level, an argument, I'm not sure I can make that argument. I think 203 probably would trump that, and there's decent law on that, but they didn't. So the city is entitled, I respectfully submit, to rely on the immunity that is, they're allowed to rely on under 2054. I'm glad to answer any questions the court may have.
I hear none. Thank you.
Thank you.
Hear from the appellant in rebuttal.
Briefly, Your Honors, I will candidly admit that Mr. Gorey's complaint in this matter does not specifically mention 2920-203. However, I think it's rather clear that the case was tried on that basis, at least up to the summary judgment stage. Matter of fact, that's the whole reason the state of Tennessee was not non-suited, which, as the court well knows, is final when a state entity is non-suited. That's the very reason they got out, because they did not own the property. So it is true that the complaint does not specifically mention 2920-203, but certainly that was the basis of the claim right up through the summary judgment stage. With regards to the public duty doctrine, we put in our brief a lengthy citation. I don't want to bore the court with it, but basically from Lawson versus Maryville City of Schools, it says, but for the enactment of 2920-203, a municipality such as Maryville School System would be exempt pursuant to the public duty doctrine. But it goes on to say, if we held them exempt, then that would nullify that section. And of course, that's not what courts are prone to do. Not surprisingly, in this case, their expert says it wouldn't have made a difference. Our expert said it did. The time that it was out, the 1 year, is unrefuted testimony of the plaintiff, John Packard. He said it had been out for about a year, that he had, and again, that's in our brief, that he had called various entities and they basically blew him off and said, yeah, that's not our department or what have you. So nobody refuted that it was out for about a year. We also put in our brief, and I think it's unrefuted, that Mr. Packard said that had those lights been functioning, he would have pushed the button. And so that's also unrefuted. He kind of alluded, it sounded like to me, to sort of a discretionary function immunity argument. That for sure, to my knowledge, has never been raised in this case, that they had discretion. And I think, again, if you assume a duty of care, then that sort of, in my mind at least, should trump the immunity or the discretionary function immunity. So with that, we respectfully request that the case be remanded to the trial court for consideration of assumption of a duty. Unless anyone has any questions.
I hear none.
Thank you very much.
Thank you. Court's thanks to both counsel. We appreciate your argument this morning and your briefs.
Thank you, Your Honor.